Good afternoon. This is Erick Widman from Passage Immigration Law, and hope you are staying healthy. We've had a number of staff get sick over at Passage Immigration, and yeah, I was sick last week too, but thankfully made a strong comeback, and I'm glad to be with you here all now. And one of the key questions I got asked this week is, what is the common experience for adjustment of status applicants at their interview? What is involved in an adjustment of status interview? So I want to give a quick and extended overview of how that process works. If you have a family-based adjustment of status green card interview, what do you need to know? So in general terms, it's going to take roughly a year from the time that you apply for adjustment of status through your spouse to get the interview set up. At the interview, you're going to be asked to bring in your spouse plus original documents plus new supporting evidence to show your genuine marriage. At the interview, you'll want to arrive 20, 30 minutes early. Your USCIS officer will come out. He or she will be dressed in plain clothes, not like a CBP officer at the border. So your immigration officer will invite you into, say your officer's a man, into his office, and he'll say, "Please remain standing. Do you swear to tell the truth?" And he'll also ask you to raise your right hand. And you say, "Yes, I swear to tell the truth. I do." He'll then ask for you to take a seat and for your ID, wanting to get your driver's licenses and passport. If you don't have a driver's license, you would want to provide your state ID. And if you moved recently, it's typically okay to have ID from the prior state you were living in. But the officer will ask, "Well, why haven't you updated your ID yet? It's fine if you just moved." But you want to make sure that you show that if the office you're in has jurisdiction over your case. So if you don't have state ID, bring in from that specific state, bring in proof that you live at your current address, such as a utility bill, bank statements addressed to your current address. The officer will then ask, typically, some other general questions about, okay, is this your correct address? Where do you currently work? And potentially phone number, any other travel recently. More general questions about your green card application that you already submitted. So you submitted roughly a year earlier, Form 485, the I-130, 765, the affidavit of support, your travel, advanced parole travel request. So you submitted all that, and the officer will have that on his desk. So he's flipping through this huge stack of paperwork, asking questions about that document and all the forms and supporting evidence. Then the officer will typically transition into questions about your genuine relationship. And your officer will often ask a simple question such as, "How did you meet? And how did you decide to get married?" We'll dig further into that. And by the way, a few weeks ago, I attended a 4-hour interview where it was called a Stokes interview. It was the longest one I had done, I think, ever. And it was 4 hours about their genuine relationship. So you don't want a Stokes interview, but hope is not lost if you do get one of those, because our clients got approved after a 4-hour interview. Most of the time, it's just a half hour. But that's when they're suspicious of your marriage and want to dig out evidence that they could use against you to deny your case. So sounds vicious. It often is. Most people, though, don't have a Stokes interview. I'd say maybe 5 to 10% of the time you are separated and subjected to this really long interview process. But most of the time, they're just asking for proof about your genuine marriage, such as, have you met each other's parents? Who was at your wedding? What is your spouse's birth date? Sometimes this is usually a Stokes interview context, they will ask questions like, what's the color of your living room rug? And that's fairly subjective. And one client, the husband said, oh, that's tan. And then later, because they were separated, the wife replied, gray. So that is normal and it's okay. And that's pretty close. You're not going to expect to have someone say lavender or chartreuse or have really specific answers. In fact, if it's too close, you're going to look suspicious. So because you have a genuine marriage, you can have confidence in that, even if some of the information is not exactly the same. We are definitely not robots. All right, at the end of the interview, they'll definitely have asked one of the most important questions, which is, how did you enter the United States, foreign national? And did you enter with inspection? And what was your intent at that point? So they're asking about that. At the end of the interview, they'll ask for these eligibility questions, such as all these bad things you've never done. Have you ever smuggled drugs? Have you ever trained in a terrorist camp? Have you been voting in a US election? Those questions are important ones, and you'll have looked at those before. So I'll stop it right there, and we're going to jump into the other questions. Okay, are there any updates on accepting new Daca applications? Sadly, unfortunately, no. There's pending litigation, and the Biden administration is saying they're going to take steps. They've been saying this for over a year to help dreamers, to help the Daca process get going again. But it's currently where it was several months ago after the latest lawsuit, that they'll accept renewals, but not new Daca applications. So that's a bummer for those who finally realize they're eligible and have wanted to apply. There might be some executive orders coming from Biden, but right now he's focused on other legislation after they sadly failed to get the immigration reform through the Senate parliamentarian and that budget reconciliation process. So bummer about, bummer about a lack of new DAPA applications, and they're simply not accepting those now. Question, does receiving emergency rental assistance due to COVID affect sponsoring parents? I'm the only sponsor and my income is still above the 125% for a family size. So one good general principle is that the public charge rule that Mr. Trump had implemented with his administration, that additional extra burdensome requirement went away. That was removed due to litigation, and the Biden administration also got rid of it. So the extra form that they were requiring and those additional requirements are no longer there. Pardon me. I did have a cold last week, getting better. But you do want to make sure that the beneficiary is not receiving public assistance where she should not. That could still trigger a different public charge issue. But you're wondering, since you're the sponsor and presumably you're the US citizen, you're the green card holder, emergency rental assistance, will that affect things? My understanding is no. And you can receive public benefits. You're the US citizen. I presume you might be a green card holder, but there are way more benefits that are available to you that won't penalize the person you're sponsoring. And if your income's above the 125% poverty line, you should be fine. That's good. Okay. I applied for an I-130. Next question. For my parents and my sister. All the I-130s got approved, but my sister's visa won't be ready for another 10 to 15 years. Yes, it is such a long, outrageously long period. Can we expedite my sister's visa because she's the nurse for my old parents? So that there is expedite criteria available. You can request an expedite, but you cannot speed up the eligibility period when your priority date becomes current. That's all subject to the visa bulletin. So you can't speed up how quickly the visa bulletin goes. And that, if you look at that, go to Visa Bulletin online, and you'll see the chart of when your sister, your sibling is going to be able to, and her priority date's current. So you can't speed up that process. But there is something called humanitarian parole that in some instances, especially where your sibling or the beneficiary might age out, you could pursue humanitarian parole in some situations like this. It's possible, potentially, your sister needs to be with your family because she's the nurse for your old parents. So possibly a humanitarian parole rationale could work. But otherwise, there's just a lot of people in the same boat. You have to wait a long time for your sibling's visa priority date to become current. Okay, after submitting an adjustment of status for my parents, we got the confirmation receipt, and they provided a new USCIS online account number, even though in the forms, we wrote their existing account number. By the way, we've been having technical difficulties at our law firm too with these poorly implemented online accounts. But we'll see exactly what your problem is. You got the confirmation receipt. They provided a new USCIS online account number, but you'd submitted it with their existing account number. Do you need to open a new USCIS online account? We tried to add the case in their current account, and it says it's linked to a different account number. Yes, I agree. It's a big mess. The big picture, though, to keep in mind is you got a receipt notice. At least the case is moving forward. Even if they bungled and have a messy online accounting system with these different accounts that are linked incorrectly, your case is moving forward. So that's most important. And when you look up that case number, you should be able to see that the status is listed. If you don't see that, then that's problematic. I don't have a lot of optimism that you're going to be able, to get these USCIS online accounts straightened out. And adding in the case in the current account, you might call USCIS, the 1-800 number, but that's probably not going to work well. You could contact the Emma chatbot and explain the problem. I just don't think that the investment of time in trying to get this sorted out is going to be worth it when they might not even have a technical solution. But your case is moving forward, thankfully. It's just going to be harder to manage it because you can't monitor it online. Next question. If someone enters the country illegally, does it matter how they enter the country when they want to fix immigration status? So great question. So yes, when you refer to entering the country illegally, so that could mean that you provided fake documentation to a CBP officer at the border and you misrepresented it, you provided fraudulent documents. So that requires a different type of waiver than if you just came through with the help of a coyote coming across that one of those dangerous passes, California or Arizona. That requires an unlawful presence waiver, and you might need 2 waivers, by the way, but that is different. And so there are hundreds of thousands of people who have done that, and there are many US employers offering jobs to entice people to come over. People are responsible, of course, but we have a really dysfunctional system where we need the labor, and then we want to treat people unfairly as indentured servants and keep people in the shadows. That's not fair. So there should be a way to move forward, get legalized, and get jobs here with an expansion of these temporary working permits and these visas that would enable that. But your questions about whether it matters how you enter the country illegally, it does, and that will affect the types of waiver or waivers you'll likely need. Okay, next question. You applied for a green card for your spouse a year ago, being a green card holder, and now you'll become a citizen in a month or so. How will that affect your case? So you could, if it's going to help the processing time, you could upgrade your petition and you apply for the spouse green card. I'm trying to determine if, by the way, your spouse is in the US or not. And in many cases, like the visa bulletin for green card holders in the F2A category, where you have a spouse that you're petitioning for, it's current. So that preference category is current. And so that's effectively the same speed as an immediate relative petition that a US citizen would petition for. So a US citizen petitioning for a spouse, it's effectively right now the same speed as a green card holder. Sometimes it can be even slower for a US citizen to petition for a family member. So in that case, you don't want to have your I-130 petition upgraded. But you could notify USCIS with a letter that you become a US citizen, and you'll want to do that if it will in fact speed up your case. Excuse me. But F2A is current, so it's not important or essential to do that. At the interview, by the way, they will want to know your current status as the petitioner, and you would provide your certificate of naturalization. And you're going to get that certificate of naturalization at your oath ceremony in a month or so. Okay, here's the next question. With respect, how long should I wait? I'm so worried and disappointed. You had appealed for something in 2020. It's been more, and you are waiting for some reviews. It might be an SIV case. I'm not sure. Sorry to say that it's been 4 to 5 times. You changed your home location, so you've moved a lot. So I am not clear what the question is, but next week, please just resubmit it with some more details of exactly what type of case it is and specifically what you need help with. Next question. For our fiancé visa, I received an I-797 notice of action rejection. I'm sorry to hear that. It says that the application type was not completed. So, quote, application type was not completed. What is this? And what is our eligibility category? You put C9. So I'm suspecting that this is part of the adjustment of status process following your spouse's entry. Your fiance came in the US, got married to you, and now the C9 category refers to the employment authorization document, the EAD, which is Form 765. C9 is the category there for the eligibility for that EAD. So for adjustment of status, that's correct. I'll double check that if it's different for a fiance. I don't think it is. I think we put the same thing down there because it's a marriage-based adjustment of status. But I'm going to look at the instructions, and if you want to email us at support@passage.law, I'll reply back with the answer to this question confirming that. But yeah, you might want to provide a few more details here. I think C9 is correct, but if I don't have the foundation of the question correct, that you're not doing an adjustment of status, if your fiance visa is somehow held up overseas with consular processing, let me know about that too. But yes, email support@passage.law. And there we go. It looks like one more question came in on, perhaps this is YouTube. Okay, does a re-interview in a different country, would that be different from the interview of the first country? So if you have a second interview, this does happen from time to time at a second country. For example, if you had to switch the location of your interview, you moved, or your case was held up in administrative processing for a long time, and then maybe we did a mandamus lawsuit and they're going to re-interview you. Sometimes they cover the same ground, or whether it's your family member. So it's nothing, it's usually a positive thing. It's nothing to be alarmed about. They have to do an interview in that country to issue the visa from the US embassy or consulate in that country. So this happens from time to time. It's normal, and it's a good thing, where an interview is usually good. And many people are waiting a long time to get an interview, or even to get re-interviewed. You'll have to do a new medical, most likely, depending on how long it's been, and getting all your necessary supporting documents is a challenge, but you can do it. And that's great that you have an interview coming up. Because of COVID, many places are severely delayed. Many embassies have a huge backlog for interviews. So good job. Congrats. We'll end it there. Thanks for tuning in. Take care and have a great week.